answer the question whether such an activity would be sustainable in the long term, we could take a look at the long-term sustainability guidelines, of course, and observe whether a state has adopted proper policies and regulations, or whether there is appropriate planning and procedures. However, we should first take a step back and question whether the space treaties are actually applicable in the first place. And the hesitation here has to do with the fact that the space industry was traditionally focused on producing objects on Earth destined for space, which is the reason why within the space treaties we see the terms launching state, space object launched into outer space, and space object used interchangeably. Therefore, defining these terms in the context of space-made products is crucial. And that is because, first of all, in order to apply any law in outer space, and specifically for space-made products, the state needs to establish jurisdiction. And the jurisdictional link, as we know in the space treaties, is the registration. Now, without a launching state and without a space object to be registered, it is not clear which state has jurisdiction over the object and which state will apply its national law, the long-term sustainability, etc. At the same time, this lack of clarity complicates also the application of the default liability regime of Article 7 of the Outer Space Treaty and of the Liability Convention. So the main question arising is whether space-made products are space objects and whether we can actually identify launching states. That for the launching state, we have the four different types: the state that launches or procures the launching, and the state from whose territory or facilities an object is launched. For space objects, as Ian already mentioned, we have more of a clarification that the term also includes component parts of the space object, the launch vehicle, and parts thereof. The fact that we only have a clarification has led to interpretation of the term in the literature, and a general understanding accepts that there is a space object when we have a human-made artifact that is either launched or intended to be launched into outer space. In practice, the definition also, I shall say, depends on the national law of the state of registry, how that defines space object. Having these definitions in mind, with this general understanding that we need a space object to be launched or intended to be launched in outer space, the next logical step would be to try and apply them and see if we have any legal gaps regarding space-made products. Now, following a hypothetical life cycle of a space-made product, we should first start from the production phase. Let's say that we have the object in production. In this case, there is no launch, and thus, following this general understanding, there is no space object in line with general. However, this space-made product in production actually belongs to the manufacturing station, and in such cases it has been supported that it will follow the fate of the registered manufacturing station. So, there will not be an additional registration, and regarding liability, the launching states will be the same as with the manufacturing station. Here the problem is that it is possible, at least in theory, that the manufacturing station is not registered, and that could be the case if this station was constructed in space by parts that were registered individually, and there is no further agreement between the parties. Let's imagine something like the ISS, but without the intergovernmental agreement. We have to divide the different scenarios depending on how the product is going to be used. Here we identify three scenarios. The first scenario we could see is that of a propellant. And what do we have here? We have a space-made product that is launched, that leaves the celestial body where it was manufactured, as a component part of another space object. Due to the fact that the definition I mentioned earlier includes in the space object also the component parts, the answer here is easy in the sense that it will follow the registration and the launching state of the object that it was used to refuel. Now, the second scenario concerns the case when the space-made product leaves the celestial body but not as a component part, autonomously, independently. That could be the case if at some point there was a 3D printed CubeSats, for example, or objects that are released in outer space from another celestial body. In this this case, we will have to examine whether this product is actually launched into outer space. If we follow an inclusive verbal interpretation of the term, we can support that to launch means to set off or release, and that into actually indicates movement. So with an inclusive verbal interpretation, we would find a space object that could be registered, and also we could identify launching states. This would be the state that launches or procures the launching, and the state from whose facilities an object is launched. Of course, we cannot have the state from whose territory a space object is launched because of the non-appropriation principle. We could see is that of a space-made product that does not leave the celestial body, so it is not launched, and it does not belong or is a component part of another space object. An example of that would be a human settlement station that is 3D printed. And for this case, there is no broad enough interpretation that would actually lead to considering the settlement station as a space object, as an object launched into outer space. As seen from this analysis, the actual issue is that the jurisdictional link of registration, the way it is phrased now in the space treaties, does not really work. And that is why the next logical step would be to look for alternatives. The first link that has been proposed is that of ownership. This opinion is based on Article 12 of the Moon Agreement and the use of the pronoun later in this article. Also on the fact that ownership is not affected by the presence of objects in outer space. However, as already mentioned, the Moon Agreement has very low acceptance, and also ownership would not be practical properly as a jurisdictional link in the long term, considering that the market is envisioned for space-made products. Another link proposed in the literature is the effective control link. This is taken by human rights jurisprudence and actually says that since a state exercises control over space activities under Article 6 of the Outer Space Treaty, this effective control could actually extend to the object itself. This solution sounds more reasonable. However, it has not been affirmed judicially in the context of state space law, and as such is only theoretical. Now, regarding liability, the truth is that if we do not have a space object and launching states, we cannot apply any of the two legal regimes that apply to the space treaties. Also, with the Liability Convention, even if we could apply it, we still have the issue that we will need to find fault, since the damage would occur probably in outer space. The only other legal basis would be on the international level, international responsibility under ARCIMA, for which we would have to find a wrongful act or omission of the state. But in order to have that, we will need first to specify the obligations regarding what is permitted from the state. And so far, we don't even have best practices regarding space-made products, so this will not be practical. The other way to go would be domestic legislation, which is of course allowed. But again, in order to apply domestic legislation, we return to the issue of jurisdiction. We would first have to find a link between a state and a particular product. Therefore, we can conclude that the liability alternatives are also not satisfactory at the moment. As a third alternative for the future, we could also explore whether product liability regime could be applicable as a suitable alternative. Now, this would hold the manufacturer liable instead of the state. We would avoid the diplomatic channels from the Liability Convention, and it would be under a strict liability regime. Keeping in mind that in the EU such a regime was established to correspond to the increasing technicality and the risks inherent to the technological production, such a regime sounds reasonable, sounds like a solution, but again this would be at a later stage when we would have a major space and a major space insurance market. To conclude, the current legal regime is far from being clear and requires complex structures and interpretations, and even if we apply some of them, again, we only cover partly the problem. Furthermore, both issues of jurisdiction and liability are important also for the industry, in the sense that we will not see any investments if these are not solved in this unclear legal environment. Therefore, my conclusion is that before we start discussing whether such an activity will be sustainable in the long term, and to actually ensure that it will be sustainable in the long term, we should first address these legal gaps. This, of course, the solution would be to propose to reassess the space treaties, but there is no appetite for that at the moment. So, in the meantime, space actors must be mindful, at least, of these legal gaps and limitations and anticipate them. States should probably amend their national laws to include space-made products in their national legislation, in their definition of a space object, and parties should anticipate them in intergovernmental agreements and in contracts. And with this note of a very much needed multi-level approach, I would like to thank you very much for your attention.